All rise. Court silent session. The Honorable Minu Sasser presiding.
All right, good morning. You guys are meeting ready? Very nice to see everyone. Good morning. All right, please be seated. Let's go ahead and get started, everyone. We have court order at 8:30. All right, let's go ahead and go in record. We are being Dr. Lavado versus West Palm Beach Physicians Group. Could counsel please state their appearances for the record?
Good morning, Your Honor. Brian Buckstein for the plaintiffs.
And Michael Napoleon as well for the plaintiffs.
Morning.
Good morning, Your Honor. Peter Goldman for the defendant and Jamie Gelfman for the defendant.
Good morning. Very nice to see everyone here. We are here on the joint motion for preliminary approval of the class action settlement. And for the record, I had a full opportunity to review the motion. I reviewed the pleadings as well. And before we get into the substance of the motion, you all are just incredible, incredible attorneys, and I want to congratulate you for a fantastic job for both sides as well. With that being said, counsel, like to proceed?
Good morning again, Your Honor. As you've seen from the documents, the plaintiffs have obtained 100% of what they were seeking. The costs and attorney's fees are going to be paid by the defendant outside of that. So we're delighted, and that's why it's an upheld motion.
Absolutely. Let me hear anything now, Mr. Hancock?
No, that's it.
All right, Mr. Gold?
I echo those comments as well and appreciate your Honor's comments. This is a good settlement, sort of a win-win for everybody. We get everybody CMS compliant, do it the right way, and get these folks paid.
Wonderful. That's exactly what we need to do. That's what good attorneys do. So congratulations to your clients. I wish your clients were here to see what a fantastic job that you guys did, and how fortunate that they were to have you guys represent them. So I'm going to go ahead and enter the order approving the joint preliminary approval of the class action settlement, and I want to commend you all and congratulate you guys.
One last thing, Your Honor. So we'll have to have a final fairness hearing at sometime like mid-June or after, and that
Okay.
depends on your schedule.
I can do it whenever. Just check your calendar. Michelle's here at your convenience. Just email Michelle, and we'll be happy to do it. Set it for you guys.
Okay, so I think, does the order have a blank?
It does have a blank, so just let me know. Do you guys want to? We can just put.
Why don't we email, if that's okay?
I'll hold on to the order. Just email the dates. Let me know what works best with all your calendars. Email Michelle, and we'll put the date in once you guys.
Terrific. Thank you.
Perfect. Thank you. Nice seeing you all. Have a great day, everyone. All right, let's go ahead and get started with UMC hearings this morning. First up, I have this is Dennis versus Comcast. Counsel ready on that one? Do we have a court order? Yes, ma'am. Wonderful.
Good morning, Your
Good
Honor.
morning.
Green Mark of May and Mark for the plaintiffs.
Contractor, I'm here for Boca Town Center Condominium Association.
Good morning. Very nice to see both sides. We are here on Defendant Boca's motion to strike the second amended complaint as a sham pleading and motion for attorney's fees and costs.
If I may.
Yes, sure.
There's an attorney who's waiting.
Oh, yeah. What's the phone number?
Ryan Sarhan. His phone number is 321
321
430
430
5297.
5297. Let me give him
Sarhan. Yes.
Sorry. Okay, let me give him a call.
Hello?
Oh, good morning. This is Judge Sasser. I'm calling Mr. Sahan. Are you ready for the hearing?
Yes, Your Honor.
Wonderful. We have counsel here in the courtroom, and if you'd like to state your appearance for the record, counsel?
Yes, Ryan Sorian, I'm the Comcast.
Wonderful. And we have separate hearing this morning. Defendant's motion to strike the second amended complaint as a sham pleading and motion for attorney's fees, which I read, and you may proceed with the motion when you're ready, counsel.
Yes, Your Honor. I'd like to pass up one other thing that
Sure.
Plaintiff's counsel has filed today.
Sure, let me take a look. I didn't see anything else. You can see what it is.
It's the
For the record, please.
it's the
Oh,
services
services.
agreement and
It's the services
lease
agreement?
that you filed.
That's one of the documents. Yes, Your Honor.
Okay, got it.
Your
Okay.
Honor, so this arises out of fees in the cable box.
I know, we talked about it before.
Right. And it's our position that plaintiff has now attempted to avoid the operation of Your Honor's prior court order by alleging that my client, the association, owned or operated this cable box. That's not what said in the original complaint. That's not what the affidavit says. And now we have the services agreement and lease agreement here that says this is Comcast's exclusive property. We can't interfere with it. We can't touch it.
I know, my only problem is sham pleading is it's a high standard. That's the only problem. I have to take the allegations as true. Maybe we should do this on a motion for some reason. It's very, very hard. I have to It's a very legally difficult standard. I know what everything says, and I know we talked about last time.
Well, there is a rule, Your Honor, and it's not often used, but this is, it's our position, it's an appropriate case, and now we're held into this expensive litigation.
It doesn't need to be expensive. Do a really short pro forma motion for summary judgment. If I grant your summary judgment, they're going to get tacked on with fees and costs. I just need to do everything legally, procedurally correctly. It's just such a high burden on a sham pleading that the standard is very difficult. Those cases don't usually withstand appellate review without, it's hard, let's just put it that way. I would do a pro forma motion for summary judgment with all the documents.
All right, Your Honor.
Just to dot all our i's and cross all our t's. I wouldn't get into a lot of expensive litigation. Anything to respond?
Yes, Your Honor, of course.
Are you sure you want to be suing the association?
Definitely, without a doubt.
Okay.
What the counsel and his party has done to the court is stated multiple misstatements
Okay.
in that motion. We filed our opposition in response.
Yeah, I saw that.
Which shows that in our first amended complaint, which was not court ordered, it was
Yeah.
because of scrivener's error.
Sure.
All of the facts that he stated are incorrect. And in the first amended complaint, everything we stated there is also in the second amended
Okay.
complaint.
And the standards I have to take them as true. I understand.
Right. But there's a couple of other matters we have noticed and we need to address real quickly.
Okay, sure, of course.
Mr. Sarhan is on the phone because he has set a deposition this Friday for my client,
Okay.
Patrick Deninis. We have no problem with that. In fact, he wants to get it.
Got it.
The problem, and we will withdraw, Mr. Sarhan is aware, our motion regarding Comcast for a protective order as to this coming Friday. Because
Okay.
they did yesterday supply our, the answers and responses to our discovery.
Okay, good.
This defendant has not. Not only has this defendant has not.
Did you file a motion to compel?
I did,
Okay,
a
so-
motion to compel,
Okay.
a motion for protective order. They filed a cross notice for the deposition and have not given us one iota of
Okay.
any response to discovery.
Can you hear a response?
Your Honor, when that discovery came due, we were not a party because Your Honor had dismissed the complaint.
Okay.
We were not a party. We filed an objection. We then filed a motion to strike for sham
Okay,
party.
You're going to have to answer some discovery. so-
All right, well, I can't do it by tomorrow. Your
Okay,
Honor.
yeah, so we-
I'm gonna need 20 days to
The problem, Your Honor, is 20 days is too long. This discovery was filed February 11, 2019. Your Honor,
What do you need before the deposition? Just tell me. Let's
we need 5 days before the
No,
deposition.
what do you need everything?
Oh, I'm sorry, the answers to the initial interrogatories,
Okay.
the answers to the expert, which is probably going to be none,
Yeah.
and the request for reduction.
Okay.
None of our discovery has been responded to.
Okay, let me hear a response then. I mean, I'm not going to make you respond by tomorrow, but the problem is the deposition's on Friday.
I'm leaving next week
Okay.
for a week and a half out of
Okay.
town,
Okay.
block plan, family reunion, going out
Okay.
of
So I'm
the
going to
country.
grant the motion to compel. I'm not going to shorten time for a response by tomorrow. I'm going to grant the motion to compel. I'm going to give him 20 days to respond then.
Okay, then, but 20 would be too long for this reason, if I may, Your Honor.
Sure.
Mr. Denendis needs to go see about his mother in New York. His father died.
Okay.
He's willing to put it off, say, until next Friday or the Friday after, but he's got to get out of here, and this is what's holding him here.
Okay.
Our second amended complaint was filed March 19th. That's more
I'll
than
do
30.
15 days then. 15 days to respond to discovery. That's fine.
And that
I'm out of town most of that time. Your Honor.
Okay.
I'm not I'm not sure, are we having a deposition tomorrow? Are we putting
No,
on
I
what's?
guess he's
because I
canceling.
don't have
I guess he's
response.
canceling the deposition.
All right, well then, I'm not sure what, you know,
Okay.
this
He's something about
compressing
his
this
client
time
going
is.
out of town.
Yeah. Could we have an order that deposition is set on a date certain, a Friday?
That's fine. You guys can pick the date that we can.
That's the
So
problem.
that's fine. I'll give you the 20 days then. Let's just pick a date that works with all council will coordinate the day of the deposition.
All right,
Just do it by
thank you.
court. So
So
that's
the-
all. And I would follow your MSJ as quickly as possible.
So the deposition within 30 days?
Yeah, let's do deposition. So discovery within 20, depo within 30. It would be 10 days after the discovery, and then you can call your MSJ and we'll get a set for hearing. All right, thank you guys. Have a great day. Thank y'all.
And how about the order? We have blank orders with
Yeah, you guys can fill them out. Just hand them to the bailiff. Thank you so much. All right, let me please go ahead and do Wells Fargo Bank versus Edwards. Yes, sir. All right, and I don't have any other paperwork on anything else. If anybody else has any UMC paperwork, please hand it to the bailiff. This is my last one. So, all right, good morning. Good morning, Your Honor. All right, this is Wells Fargo versus Edwards. This is defendant's motion to dismiss. Could, reporter? No? Okay, all right, I have the motion. You may proceed.
Your Honor, as you can see in the motion to dismiss, if you look at the actual complaint, it has multiple endorsements, some of which are marked canceled, some of which are illegible.
Okay.
In order to properly evaluate whether a plaintiff has standing in order to begin this, initiate this lawsuit, that needs to be established. It can't be
I
established
think
with-
everything is true on a motion to dismiss, and they just attach, if they're gonna, they may not survive summary judgment. So motion to dismiss is denied. How much time do you need to answer your complaint?
20 days, Your Honor.
10 days, okay? That's fine, Your Honor. That's fine. All right. Any other paperwork? Otherwise, just come on up. Which case are you guys hearing? Come on up, guys. I'm up. That's it. You guys are the last hearing. Harris versus Shutters Condo, please. Come on that one, Your Honor. Okay. All right, you guys here on Harris versus Shutters Condo, could counsel please take their appearances for the record?
Good morning, Mary Rosenblatt on behalf of Ferguson.
Lori Nanoff on behalf of Shutters Condominium.
All right, good morning, everyone. This is defendant's motion to dismiss with prejudice and motion to enforce the settlement agreement and for sanctions. Let me just ask you, on the motion to enforce the settlement agreement, is that evidentiary? Do we need to have evidence and testimony on that one?
I do not believe so.
Is there any opposition? Is there any factual dispute?
Well, we're both defensive.
Yeah, nobody else is here,
And Mr.
so-
Harris is not here.
Yeah.
Just so you know, the house, we have a foreclosure judgment against Ms. Harris.
Yeah.
It's set for sale in June.
Okay.
So the association today, we're not here enforcing we have a motion to enforce
you
as
just
well.
want the
I'm just
benefit.
here because
Okay, that's
Ferguson's.
fine. All right, so with that being said, why don't you go ahead and proceed on your motion to enforce the settlement agreement?
Okay, thank you, Your Honor. So repairs to the Ferguson's unit were completed around January and February of 2018. The settlement agreement was executed in February of 2018. The defendant paid for repairs pursuant to the agreement, and in June, we were notified, as Your Honor is aware, of a new leak in the plaintiff's unit. We handled that immediately, went out, inspected, conducted repairs. Plaintiff's counsel then requested a leak detection company, and we agreed to proceed that way with plaintiff's choice of leak detection. We attempted numerous times to inspect. Plaintiff refused to allow it. Your Honor entered an order requiring plaintiff to permit inspection within 20 days. That order was signed on November 27th of 2018. Plaintiff still continued to refuse to allow inspection, and that's when plaintiff's counsel withdrew. And plaintiff failed to comply with that order despite numerous attempts to comply with it. And thus, she also failed to comply with the settlement agreement. So we're seeking enforcement of that and sanctions.
That's fine. Now, what sort of sanctions are you seeking?
Fees and costs from the date.
From the date, okay, that's fine. And I looked at everything, that's fine. I'm going to go ahead and grant it. And I'm going to grant entitlement. The amount we might have to have a separate evidentiary hearing on because if it's contested then. So, but grant us entitlement.
The only thing I want to make clear, because we have a cross claim.
Yeah.
And where you do not want the cross claim dismissed.
No.
Just in case there is an issue. I mean, I think have we pursued our motion to enforce as well,
Yeah.
we would be in the same position as them getting it dismissed and all of that. But she hasn't made the repairs that she's required, and we gave her the money. So if the foreclosure...
So it's a breach of the settlement agreement. There's no-
Right, so there's a breach, and we want to preserve our rights to go against that. And God forbid something happens, and we still need to preserve the cross claim.
Okay, cross claim going
So
forward.
we don't care if Harris's claim against Ferguson is dismissed, as long as the association's cross claim is
Okay.
preserved, and we'll come back later to enforce. If for some reason a foreclosure sale
Okay.
gets canceled, we'll be here to enforce.
Wonderful, that's fine. Okay,
Otherwise, it doesn't
so
make
I'm going to
sense.
go ahead and grant the motion. Let's do the other motion then as well.
Yes, Your
And
Honor.
Michelle, go get your phone. Take a picture with you, please. Okay, go ahead, I'm sorry.
Thank you. So following counsel's withdrawal, Your Honor entered an order requiring plaintiff to retain counsel and file a notice of appearance or file a written notice of self-representation
Okay.
within 30 days from the date of the order, and that order was entered on January
Yes.
29th. Now, no notice of appearance has been filed by new counsel, and plaintiff has not filed a notice of self-representation. So not only did she fail to comply with all of Your Honor's orders, she
Yeah.
failed to comply with the settlement agreement and this order requiring her to file a simple notice of appearance either way. So we request that the matter be dismissed with prejudice, and
The only problem is I have to be Gazelle here. I can't do that. I just simply can't. I have to make, even though she's not here as a plaintiff, I have to make findings. I have to do it as a Gazelle hearing. I can't dismiss it with prejudice. I could dismiss it without prejudice then and give her leave to try to, again, cure this. Otherwise, you need the order show cause. I just can't dismiss it with prejudice.
I would See, in my opinion, the settlement agreement resolved the case.
I got
We
it.
don't need to
Yeah,
have
you don't,
dismissed.
yeah, exactly. The case is
So,
over.
It's over, it's
Case
done.
is
and this-
over. I agree
she
with Ms.
breached-
Hanoff.
yeah, She's breached the settlement agreement,
I'm
we
going to
can
close
go
the
for her on
case
that.
based upon the motion to enforce the settlement agreement. Just send me a final judgment then. That's the easiest way to do it.
Okay, and if I may, I also request the fees and costs as well as interest since that date of the order, November 22nd.
What's the basis of the interest? You can't legally get that. I'm so sorry. I can't give you stuff that you're not legally entitled to just because she's pro se. So I can give you fees and costs for violation of settlement agreement, but I can't give you fees and interest. There's no legal basis. So, okay, to the motion, you're exactly right, Ms. Hanoff. That's the legal way to do it. Motion is for settlement agreement is, the case is over at that point in time.
It's
Other
over,
than
right.
talk about
I
it.
mean, the settlement agreement does call for, once all the repairs are done and everything is done, for plaintiff to dismiss the case, but I always take the position that's not necessary since you haven't agreed or.
Here's what I want a detailed order, granting your motion to enforce settlement agreement, indicating that she, excuse me, she failed to comply with the terms of the settlement agreement. The association's cross-claim will remain pending if they would like to do so. If you want to keep that open, that's fine. Otherwise, we can go ahead and just, we can close.
Well, we're not dismissing it.
You're not dismissing. Oh, that's fine. So the motion for settlement agreement is granted for failure to comply with the set clear and ambiguous terms of the settlement agreement, and the case is closed. And then fees and costs are granted to be,
The case closed, we just add in there reserve jurisdiction to enforce.
oh, that's the way to do it. Okay.
To enforce these, because the association has a motion to
Okay.
enforce, and Ms. Harris did file a motion to enforce, but
Okay.
her motion to enforce goes outside of the settlement agreement.
Okay, that makes
So
sense.
It's,
Okay.
no.
No, that's fine. I
I
think
just wanna
that's,
make sure we have
that's the proper legal way to do it. Okay, all right, thank you guys. And that accomplishes what you want. You get your fees and costs, case is over, and then you the association can take its rights.
Great.
All right, great, you guys. Thank you guys. Have a great day. McDade versus Brungart, that's right?
Good morning, Your Honor.
Do we have a reporter, McDade?
Yes.
We do, okay. All right, we're hearing McDade versus Brungart. Could counsel please state their appearances for the record?
Vivian Knapp on behalf of Progressive American Insurance Company.
Chris Kellum on behalf of the plaintiff, Scott McDade, and just for the court's knowledge, Ms. Brungard is a default. We've never been able to find.
Not a problem. We have the motion for continuance, which I read, and then I have plaintiff's response. So you may proceed, counsel.
Thank you, Your Honor. We provided an amended motion yesterday.
I saw that.
And all it is just laying out the facts a little bit more. Your Honor, this is a case for injury. It's an auto accident. The accident occurred January 16th of 2018. Case was filed in August or September of 2018. We filed a response and answer September 21. We thereafter immediately produced, we went ahead and set discovery. We set the plaintiff's deposition. We took the plaintiff's deposition. Thereafter, we determined that we needed to do additional discovery. We have some complicated medical background, not truly complicated, but a history of a prior low back workers' comp, of cervical fusion from 2004, and I guess there's allegations of similar injuries or aggravation. The plaintiff noticed the case for trial on January 2nd. Quickly, the court set it January 4th for this April 29th trial docket. We're asking the court to roll the case or to continue.
How much more time do you need?
Just, the IME we have is May 15th.
With Dr. Zaide, I saw that.
Dr.
Let me ask
Zaide.
plaintiff's counsel. My dockets are 6 weeks, and they're asking, at least, they need to at least be able to do the IME and minimal discovery. Can we set you at the end of the docket or the next docket? Would that be okay? And I don't roll cases. I get cases tried every single time on the docket. I special set everything. It's going to be tried either in May or June. Is that okay?
In terms of moving it to the end of the docket, obviously that would be fine in terms of dates. Our position is that they blew the cutoff, they blew the discovery cutoff, and they had since February of last year, they're the UN carrier.
I know.
They had since February of last year to set this IME and then wait till the last minute to do it. Now, when they were supposed to disclose back in February, they did not. We missed expert discovery. And so now they get this IME on the eve of trial, Judge. And now we're, I guess, left in the wind in terms of discovery against Dr. Zaide. I'm not sure how that would work. I think
You're going to get the discovery. Both sides are going to get the discovery. Well, all we would do is we would extend the deadlines. I would essentially grant the continuance and set you either on the last week of the docket or in the next docket. Whatever
Your
works.
Honor, I would just ask if you could roll this to your immediate next docket.
It's immediate next docket. You're going to get special set anyway. So that way, defendant can complete the discovery. So I'm going to grant the motion for continuance. It's not an extended delay. You guys can finish your discovery, do the IME that you need to, and that way you can do discovery Dr. Zaide that you need to. And when you guys get to e-calendar call, Michelle, we're just going to move them to the next docket. Okay. When you get to e-calendar call the next docket, you're going to get special. You'll get special set. So there's no question you're going to get reached. So it'll be basically a 3-4 week
Perfect, Your Honor.
But that gives you enough time to do
That's
discovery.
that's all we need.
Okay.
Thank you, Your
All
Honor.
right, thank you guys. Just, you'll get a new trial order today. Just indicate motion's granted.
Motion is granted.
Yeah, motion, roll to the same
Your Honor.
and you'll get a new trial order today. All right, thank you guys so much. And let me go ahead and do Hertzlick versus Siderman, please. Motion to strike notice of readiness.
I don't believe the
Do you
defense counsel
do you
is
want to
here.
call them and see if they're on the way?
Yeah.
Anybody else paperwork? Otherwise, that's it. That's my last motion. You need to come on up then. Okay, no problem. All right, this is Apex versus Antonio Gonzalez? Oh, which one is this? Oh, come on up.
He's outside.
Okay, that's fine. Tell me, come on up. That's fine. Just let me do your hair and then, guys. Come on up. All right, come on up. What case you guys hearing?
Judge, good morning. Blair Hyman on behalf of the defendant, Tower Hill. This is Catherine Coulter versus Tower Hill. Your Honor, I appeared before you about a week and a half ago on a case management conference.
I remember.
You remember? Okay, so this is the AOB case.
Okay.
And today we're here with the insured's
Other case, yes. All right.
We're moving to consolidate.
Yeah, both. Let me ask you, is there any objection?
I would object, Your Honor. I think it would be prejudicial to my client to have two separate jury trials. I'm sorry.
No, consolidation is one.
I'm sorry, consolidate the case into one. We would like the cases to remain separate.
What's the legal basis, though? Legal basis to oppose it?
Just that, the court's discretion whether or not to consolidate the cases, and my client's requesting that the cases remain separate.
Okay, I'll make that motion.
Judge, we also have a motion for discovery. We were trying to work things out. Counsel has been thrust into this position. She just started at her firm, and we're actually old colleagues.
Okay.
That being said, we have a motion to compel discovery. It's imperative in order to get these two cases on track. Our plan is to complete the very preliminary discovery to get all parties together at mediation. We don't even need depositions.
Okay, good.
That's our overall plan. However, in order to do that, we do need sufficient discovery. Our motion, as I said today, was to compel discovery responses, period. Recently, we received those. I'm not prepared to go forward on better responses to the request to produce.
Okay.
However, I have had an opportunity to go through the interrogatories, which are woefully deficient. And just to break this down very basically, what plaintiff is trying to accomplish in this case is relying on the public adjuster's estimate in order to maybe force my client to double pay. And this is one of those cases, Your Honor, where my client is truly facing undue prejudice.
Yeah. Okay,
So-
let me hear the response.
Your Honor, respectfully, we're here on the defendant's motion to compel discovery. We filed our discovery responses. I'm not on notice of, arguing but compelling better responses to the discovery.
Okay, but motion to compel also is better responses. Did you fully comply with what they asked for?
Correct.
So did you provide the information that they sought?
We did. We filed our answers to interrogatories and we filed our response to
No,
request.
but what about counsel's position that it doesn't answer what they're looking for?
Well, I think that would have to be set for another day.
It's one the same motion. Motion's granted, so I need better responses to the discovery. How much time do you need to do? Counsel, how much time? 20 days?
20
days? 20 days?
Your Honor, they're probably going to need more than 20 days.
Yeah, it's pretty detailed then. 30?
Okay.
30 or 40? Whatever you want. 30 days?
I'm willing to give them
Let's
45.
give them 45 days.
45.
So the motion to consolidate is granted, motion to compel is granted, 45 days for better responses to discovery.
To both the interrogatories
Yes,
and
to both the interrogatories and the request for production.
And I'm not going to go through the ones individually.
No, I looked at everything beforehand in advance of today's hearing. I think you need to kind of go back from scratch, and now you're on the case, and I'm sure you'll do a better job then.
Sure.
Okay.
Thank you, Your Honor.
Thank you, Your Honor. All right, let me do Hertzlick versus Siderman.
He's appeared by telephone, and I forgot, so I apologize.
No problem, I just need a phone number.
I do, let me pull it up.
Okay.
954-463-8456 is the office. We are calling for Richard Rosenblum.
Perfect, thank you so much.
I apologize.
Writing's a little-
I got you. I got you.
a little scribbly.
Not a problem, I can read it. Oh, I'm sorry. It's my 8456.
Good morning, Walton Lampard.
Oh, good morning. I'm trying to reach, it's Mr., is it Shane? Rosenbaum. I'm sorry, Mr. Rosenbaum.
Mr. Rosenblum is not in at the moment. Can his legal assistant help you?
This is actually the court. I'm calling for a hearing on Herslick versus Steven Siderman.
Okay, hold on a second.
All right, thank you so much.
This is Barbara.
Oh, good morning. This is Jeff Sasser. I'm calling on Herslick versus Siderman. Are we ready for the hearing?
I'm sorry, who is this, please?
This is the court.
No, the plaintiff's attorney has Mr. Rosenblum's cell phone number. That's the number they're supposed to call.
Okay, we'll try to find it. Do you have a cell? We can try that.
Yes, I can give you two right away.
Go ahead and give me the cell.
It's 954.
Okay.
849.
849.
4264.
Okay, let me give him a call. Thank you so much.
Okay, thank you, bye.
I apologize.
Oh, no problem.
I think I have this one.
No problem. So.
Thank you.
Richard Rosenblum.
Oh, Mr. Rosenbaum, good morning. This is Jeff Sasser. I'm calling you Herslick versus Siderman. Are you ready for the hearing?
Yes, I am.
Wonderful. And opposing counsel is here in the courtroom. This is defendant's motion to strike the notice of readiness for trial. And I read your motion. You may proceed, counsel.
Oh, okay. Hi, Richard Rosenblum here for defendant Siderman.
And I know you're seeking to strike it because you're saying depositions haven't been done?
Oh, yeah, no, I'm actually on, I'm sorry. Yeah, well, yeah, what happened was the plaintiff was very slow in responding to discovery, and I wasn't, giving him a hard time about it. They kept asking for extensions, and I said, fine. And I only recently got discovery in, and it was not the best answers in the world that I've seen, and I don't set depositions of the parties until I get the initial discovery back.
And that's fine. The only problem is there's that 50 CA case that says I can't strike it if the pleadings are closed. All I would do is tell me when you want to go, and I'll set you guys for trial whenever works best for all counsel.
Yeah, I emailed opposing counsel to see when he would be ready because I wanted it to work and I never got a response. So
Yeah,
whenever-
when do you think you'd be ready?
Not until the fall, probably. I mean, haven't even deposed. None of the parties, there's been no depositions.
Not a problem.
I don't know where that's going to lead.
September, October trial, would that work?
October would be great.
October, good?
That actually
Okay, not a problem. I'll send you a trial order today for an October trial. That works perfect.
Okay, great.
Okay, all right, thank you.
Your Honor, I actually cross-noticed a motion to compel better responses as well, so that is attached.
Yeah, we also have the motion to compel better responses. What's your response to that, Mr. Rosenbaum?
Well, there were four requests for production that I objected to. The first one was number one, they want any and all documents that in any way relate to the allegations. That's so overbroad.
Well, it would be, how about this? We can narrow it. It could be any documents that support the allegations refuting the plaintiff's claim.
Okay, I guess my affirmative defense.
Yeah, probably the affirmative defenses, yeah. Let's do the next one.
Next was number two, any and all insurance policies, which I don't have any problem providing, including claims against, in other words, my own client's first-party claims against his insurer.
Okay.
Which is, providing coverage for him, and that's quite frankly none of their business.
Yeah, that objection I'll sustain, but any other insurance policy should be provided.
Yeah, I'll provide the policy, no problem with that, I appreciate it. The third one, we only have four, any and all documents relating to work or repairs done on the building. This is a water leak situation in a condo. My guy's a unit owner. What happened was there was a hurricane. The neighbor, who's the co-defendant, left their stove on. when the power went off. When the power came back on, a week later, it started a fire, and the sprinkler system in the building activated. So they were in all documents ready to work for repairs done on the building.
Okay.
I'm not the association.
Yeah, it should just be within your client's possession.
Yes,
custody, control.
exactly, yes.
No, you don't have to worry about the building stuff, just whatever, if your client has anything responsive.
Okay, and the last one is the policy, I'm assuming they mean the association policies for tenants. This is a rental.
Is that what it is, the association policy?
Yes, and I actually did a notice of production on party, and I'm receiving those
Yeah,
from
so
the
she's gonna get those directly from the
association,
association, and again, it would be only if your client has anything responsive within their possession, custody, or control.
Okay.
Okay.
That's the rules.
How much time to respond?
Your Honor,
Yeah.
I don't mean to interrupt, but I did send out in the same request for production,
said there was
5 through 14, and he just didn't respond to those.
Oh, yeah, what about 5 through
So,
14? I thought it was just 1 through 4. Can we get better responses to 5 through 14?
Yeah, I thought there was only 7 total.
No,
there's
maybe-
14 in here.
Yeah, council's saying there's 14. She's saying that you didn't, and there's some that you didn't respond to at all.
Because I've received no documentation.
Check my file.
Okay.
I'm at home this morning, Your Honor. I appreciate it. Getting food out of my house, and my wife is not.
Oh, no, not a problem. Not a problem. Let me do this then. I'm going to grant the motion to compel. I will give you 20 days to do better responses. So just do the ones that we talked about, 1 through 4. And if you didn't respond to 5 through 14, I'll give you additional time to respond. It's no big deal.
I do have a deposition of their client on, I think, May 25th, so as long as I would like the discovery prior to
Can you
that.
get it before May 25th because they have a deposition?
I believe it's May 25th, late May.
Okay, yeah, 20 days will be before
Okay,
that.
perfect. Thank you,
Perfect.
Your
If you guys can email the order, have a great day, everyone.
Okay.
Thank you all so much.
Thank you.
Okay. All right, let me do last but not least the Gonsalves. Yeah, let me know. Come on up. Oh, okay. Yeah, that was denied. That motion was denied.
We had an original one where it was granted for a rehearing, and then I don't know if there was a date.
May I explain?
Yeah.
Michael Wargo for Apex,
Okay.
Apex Park Group. First of all, there was nothing set for hearing today, and there are no pending motions. The last motion that they filed was a motion for rehearing reconsideration of the judgment that was entered. Your Honor granted oral argument on that, and in the order indicates they should set it on UMC. That was in November of last year. It was never done. You held a status conference on March 28th, at which time you denied the motion.
Yeah, because I looked at it, yeah, so at this point in time, I did, yeah, we were supposed to do it between November, nothing got done, and then I actually looked at the papers and there was really no basis for it. It had been 6-7 months and nothing had happened, so I denied the reconsideration.
But Mayor, I had 3 deaths in the family last year, and we weren't getting emails, and we sort of don't know what's going on. We're not attorneys, and I mean, my wife filed.
It was granted.
Sure,
I know, but you didn't do anything. And we sent the order out, and you guys did nothing from November.
What was granted was the right to have
Right to have an oral
argument.
argument, yeah. And you were supposed to come to court and have an oral argument on it.
We
So-
weren't given a date to come for an
You don't
oral
know.
argument.
Yeah, you do it any day you want to.
We scheduled it actually scheduled the dates. I went on the computer and scheduled like UMC
that's
dates.
my assistant.
And then they were canceled.
Yeah, but she did it through online mail.
Yeah.
Yeah, my
And,
assistant's here, she said nothing was.
Well,
I have
we
it
got
here.
paperwork of them.
And we actually
that
sent out
that
the one.
They did.
Michelle spoke to you. Michelle's here to assist you.
Yes,
She's
yeah.
saying
This
that's
is
not
the one that
accurate.
we tried to schedule for
Your
these
Honor,
days.
Your Honor, apparently what they're doing is they're reserving time on the
Can't
UMC
do
portal, but they're nothing's getting filed.
You need to file the motion.
We did one and it was canceled.
Okay,
Our first
just
one-
argue your motion now, go ahead.
Okay.
Yeah, go ahead, just argue your motion, now's your chance, this is your one chance in court, go ahead, I read it.
Go ahead.
Go ahead.
What do you, I mean,
This is
I
for
don't,
with Apex.
Go ahead.
Mayor,
What's your legal basis?
because of the money situation, Mayor, I wasn't the original contractor. The original contractor was Mauricio, Stunning Renovations.
Okay.
He ended up walking off the job. Kevin Fife, which is the, which was the super, not the super, he's the running the work. When Mauricio walked off the job, he asked me and the guys to stay and complete the work. Well, the remaining balance that was supposed to go to studying renovation was supposed to go to us. And it was like 26, I forget the numbers, it's been so long, like 26,000. He cut us a check for 13 grand, and then before that, he was supposed to give us the remaining of the original contract that was Mauricio's. When we ran the work all the way as far as we could without, because there was materials missing, Kevin decided to take all the materials that was missing and the work that wasn't complete, he decided to take it out of that chunk of money.
Sounds like Kevin's a bad guy, not Apex.
Right, but I wasn't, he works for Apex. He's the job, he's the.
Do you have any agreements with Kevin holding Apex that he would change any of your responsibilities, anything in writing?
I don't have none of that, ma'am. I have one piece of paper at the end of the job. He was supposed to give us the chunk of money, and he ended up taking all the materials and the work that wasn't completed out of our money that we completed.
But do you have anything that says he agreed to what you just told me?
I was there on the job, I completed the work.
Do you have anything in writing? Because otherwise, all I have is I have to go over off the written documents.
Ma'am, I get so much paperwork that I'd have to dig, and.
Right, so we're going to deny the motion for rehearing because I don't have anything in writing to say what you're saying is true.
It's just.
Is there a way that we could submit it to you if we?
Not afterward. We've done this so many times.
Ma'am, I don't have that money. You know, the money that they gave us was for all the guys. I don't have that money, and there was so much extra work that we did.
Maybe you can work out a settlement payment or something.
I just I don't have that kind of money, ma'am. I don't have that kind of money,
Kevin Fife, I'm only standing here because I wasn't at this job, but he was gone for 4.5 months. This Kevin Fife called me because I guess he got the number from my husband. Because I asked my husband to come home. I said, leave, because it was turning bad.
I'm so sorry.
And he called and said, make sure he stays here, please. We really need him. I will take care of him. I said, can you please send
emails and all that
Here's
stuff?
what I
I do have emails of him
See if you
saying
can
this.
maybe get an attorney or something to help you, but at this point in time, I have to deny the rehearing without any evidence to support what you're saying is true. So I need something in writing.
I have a contract. I was a subcontractor through the contractor. The contractor walked off the job, and then Kevin, we stayed and finished,
Why don't you see if you can hire an attorney, go through your paperwork. You can always do it later on, but at this point in time, I have to deny the rehearing. Because I need something to say what I don't have anything to prove what you're saying is true. I need something.
I mean, we have the agreement that, we got that page in there where, that you wrote up with Kevin in order for me to get the money to begin with, right?
What I would do is I'm going to deny the rehearing. Why don't you call Kevin and see if he remembers.
Kevin's one turned stale on us because he's protected his own job. Because him and Mauricio had fallout and used us to finish the work.
I have documents.
But I don't understand how us, ma'am.
I can't, sir, I can't. So people can come in here and say anything without any documents to support it. I need evidence.
I mean, we got pictures. I got paperwork, we got emails.
I need something to confirm what you're saying is true. That Kevin emails? Something.
We have something. I don't have it with us.
Text, anything in
Emails?
writing.
Okay.
Anything
All right.
in writing.
I'll explain it to you.
Yeah, I need
It's
some
just, I
evidence.
don't have
And I would be happy to help
this
you.
is a big outfit.
Judge is talking, sir.
Yeah, okay, all right, thank you. Have a good day. Motion's tonight.
Do you need me to do another order?
Yeah, just do an order tonight. And then we're going to close out the case, not two. All right, order tonight, closing the case.
Well, I've got discovery native execution.
Oh, no, that's fine then, yes. You guys, they need to work on the payment then. All right.